Hold everything! Before you check your bank account, you need to hear this. Congress has just passed a new law that could dramatically change your Social Security benefits, and the details are critical for every senior, SSI, and SSDI recipient. We're talking about the Social Security Fairness Act, a landmark piece of legislation that could mean a significant increase in your monthly check. For years, millions of public service workers have seen their benefits reduced by the windfall elimination provision and government pension offset. But that's all about to change. We'll break down exactly what this new law does, who is eligible for these increased payments, and when you can expect to see the extra money in your bank account. But that's not all. The Social Security Administration has also implemented a new rule that gives them the ability to automatically check the bank accounts of certain SSI applicants. This is a major shift in how benefits are verified and could impact your eligibility. We'll explain who this new rule affects, what the SSA is looking for, and what you need to do to ensure you're prepared. This isn't just another update, it's a fundamental change to the Social Security landscape. Don't get caught off guard. We've waded through the legislative jargon and official announcements to bring you the straight facts. In this video, we'll give you a step-by-step guide to understanding these new rules and how they will personally affect you. If you want to stay informed and protect your benefits, you can't afford to miss this. Hit that like button to show your support and help us get this vital information out to as many people as possible. All right, let's dive right in. Thank you for hitting that like button. It truly helps get this information out there, and believe me, the information we're about to go through is something every single person approaching retirement or already in it needs to understand. What we're discussing today are two massive landscape-shifting changes from Congress and the Social Security Administration. The first one is, without a doubt, some of the best news to come out for millions of public servants in over 40 years. The second is a critical warning, a new rule that changes how the SSA verifies your information, and you need to know how it works to protect yourself. Let's start with the fantastic news. On January 5, 2025, the Social Security Fairness Act was officially signed into law. Now, I know what you might be thinking. Another act, another piece of legislation with a fancy name. What does that actually mean for my wallet? Well, this isn't just some minor tweak. This law repeals, as in completely gets rid of, two of the most controversial and, frankly, most hated provisions in the history of Social Security: the Windfall Elimination Provision, or WEP, and the Government Pension Offset, known as the GPO. For over 4 decades, these two rules have been a thorn in the side of millions of dedicated public servants, significantly reducing the Social Security benefits they had rightfully earned. To really grasp how monumental this is, you have to understand the financial pain the WEP and GPO have caused. Let's talk about the Windfall Elimination Provision first. The WEP was enacted back in 1983, and its main targets were people who worked in jobs where they didn't pay Social Security taxes. Think about your local heroes and community pillars: school teachers, firefighters, police officers, and many other state and local government employees. They worked for decades, serving our communities, and in return, they earned a pension from their public service job. Now, many of these same people also worked other jobs at some point in their lives, maybe a part-time job in college, a summer job, or a second career, where they did pay into Social Security. They put in their 10 years or more of work, paid their FICA taxes just like everyone else, and rightfully expected to receive a Social Security check when they retired. But the WEP came along and threw a wrench in those plans. The government's logic back in the 80s was that these public servants were getting an unfair windfall. The Social Security benefit formula is progressive. It's designed to give a higher percentage of their pre-retirement earnings back to lower-wage workers. Because these public servants might have only 10 or 15 years of Social Security-covered work, the formula saw them as low-wage workers, even if they had a successful career as a teacher or a police officer. So, the WEP was created to slash their benefits. The reduction was brutal. In 2024, for instance, the WEP could cut your monthly Social Security check by as much as $587. Imagine planning your retirement around an expected benefit, only to have over $500 a month wiped out simply because you chose a career in public service. It felt like a penalty, a punishment for a lifetime of dedication. Then you have its equally disliked cousin, the government pension offset, or GPO. This one was even more insidious and targeted the spouses and surviving spouses of Social Security beneficiaries. Let's say you're a retired teacher who earned her own public pension. Your husband worked in the private sector his whole life and paid into Social Security. Under normal rules, if he were to pass away, you would be entitled to a survivor benefit. It's a critical safety net. But the GPO stepped in and said, "Not so fast." The GPO rule reduced your spousal or survivor benefit by 2/3 of the amount of your own government pension. For so many, this didn't just reduce their benefit, it completely eliminated it. A teacher who earned a modest $2,100 a month pension would see her potential survivor benefit of, say, $1,400 a month vanish into thin air. It was a devastating blow, often pushing surviving spouses, particularly women, into financial hardship after a lifetime of work. It left people feeling like they were being treated like second-class citizens. For 40 years, public workers and their advocates have fought to repeal these provisions. They wrote letters, made calls, and lobbied Congress, arguing that they were being unfairly penalized and denied the benefits they had earned. And now, that fight has finally been won. The Social Security Fairness Act wipes both the WEP and the GPO off the books. This is a total game changer for over 3 million retirees who were affected. The law is retroactive, applying to benefits payable for months after December 2023. This means that not only will monthly payments be restored to their full, unreduced amounts, but millions of people are also entitled to a lump sum retroactive payment for the money that was withheld throughout all of 2024. The Social Security Administration began adjusting monthly payments in early 2025 and has been working through the process of sending out those retroactive checks. If you were affected by the WEP or GPO, this is your victory. It means the restoration of dignity and the financial security you rightfully earned. Now, as we celebrate this incredible and long overdue victory, we have to pivot to the second major change. This one isn't good news or bad news. It's a critical piece of information that you must be aware of. It's a new rule that changes how the Social Security Administration verifies your eligibility for certain benefits, and it directly involves them looking into your bank accounts. This is a big deal, and it's essential to understand exactly who this affects and why it's happening. This new rule, known internally at the SSA as EM 25046, went into effect on August 1, 2025. It mandates that the SSA must perform an automatic bank account verification for everyone aged 65 or older who applies for Supplemental Security Income, or SSI. This is where we need to be crystal clear. This rule is for SSI applicants, not for people receiving regular Social Security retirement or disability, SSDI benefits. This is the single most important distinction to make. Your regular Social Security retirement benefit is an earned right. You paid into the system through payroll taxes your entire working life, and your benefit is based on that work history. The amount of money you have in a savings account has absolutely no bearing on your eligibility for your earned Social Security retirement check. SSI, on the other hand, is a different animal entirely. Supplemental Security Income is a needs-based safety net program funded by general tax revenues, not Social Security taxes. It's designed to provide a minimum level of income for adults and children with disabilities or for individuals aged 65 and older who have very limited income and resources. And when the government says limited, they mean it. To be eligible for SSI, an individual cannot have more than $2,000 in countable resources. For a couple, that limit is $3,000. These resources include cash, bank accounts, stocks, and other assets that can be easily converted to cash. The SSA's stated reason for this new rule is to combat overpayments. They claim that improper payments, often due to beneficiaries having assets over the strict limit, are a massive problem, totaling billions of dollars. Before this rule, the SSA would generally only perform a manual check of your bank records if you self-reported having more than a few $100s. Now, the process is automatic and mandatory for every single SSI applicant aged 65 and over. When you apply for SSI, you are required to give the SSA permission to access your financial records through their system called Access to Financial Institutions, or AFI. If you refuse to give them permission, your application for SSI will be denied. It's that simple. So, what does this mean in practice? It means the SSA won't just take your word for it. They will automatically ping financial institutions to verify the balances of any accounts they can find connected to your name. This includes accounts you report and potentially undisclosed accounts they find through geographic searches. It also means they will look at joint accounts. This is a critical point. If you are a joint owner on a bank account, even if it's your child's or grandchild's account and none of the money is yours, the SSA presumes that all the funds in that account belong to you. You would have to prove otherwise, which can be a difficult process. This change raises obvious privacy concerns for many people. The idea of the government having an automatic, uninhibited look into your finances is unsettling. While the SSA maintains this is strictly to verify eligibility for a needs-based program, critics worry it could be a slippery slope, potentially expanding to other benefit programs in the future. For now, however, it is strictly limited to these new SSI age-based applications. So, what should you do with this information? First, don't panic. Remember, this does not affect your standard Social Security retirement benefits. But if you or a loved one is planning to apply for SSI, you must be prepared. You need to have a perfect understanding of your financial situation. Know the balance of every bank account you own or are a co-signer on. You need to understand what the SSA considers a countable asset. Not everything you own counts against the limit. The home you live in, one vehicle used for transportation, your personal belongings, and certain burial funds are generally exempt. But that savings account you have for a rainy day, that absolutely counts. If you are anywhere near that $2,000 limit, you need to be incredibly careful. It's vital to be completely transparent on your application because they are no longer just relying on the honor system, they are actively checking. Let's continue right where we left off, because the details are where the real impact lies. And there is so much more you need to know to truly be prepared. We've covered the headline news, the repeal of WEP and GPO, and the new SSI bank verification rule. But now we need to get into the weeds. This is the part that other channels might gloss over, but it's the information that will actually guide your actions in the coming months. Let's circle back to the Social Security Fairness Act, because I know what the #1 question on everyone's mind is. Where is my money? The repeal of the windfall elimination provision and government pension offset is a legislative victory, but the implementation is a massive logistical undertaking for the Social Security Administration. It's crucial to have realistic expectations about the timeline. The SSA is dealing with over 4 decades of records for millions of people. They have to recalculate benefits for every single person who was affected, and that's not a simple switch to flip. For every retiree, they need to verify the original unreduced benefit amount, calculate the difference that was withheld for every month going back to the start of 2024, and then process that as a lump sum retroactive payment. The first thing you should do right now is not to jam up their phone lines. Instead, go to the Social Security website, ssa.gov, and log in to your My Social Security account. If you don't have one, create one immediately. This is your personal portal. You must ensure that your mailing address and direct deposit information are completely accurate. When these retroactive payments start rolling out, you want to be sure there are no delays because of a simple clerical error. The SSA has stated that current beneficiaries who were affected will be the first priority. They will automatically adjust the monthly benefit amounts first. You should see this change reflected in your monthly checks before the lump sum payment arrives. The retroactive payments will likely be processed in batches throughout the latter half of 2025. Be patient, but be vigilant. Keep an eye on your account and your mail for any correspondence from the SSA. Another critical question is what happens for families where the public servant has already passed away. If a person who was affected by the WEP or GPO died after January 2024, Their estate is entitled to the retroactive payment for the months they were alive and their benefits were reduced. This is not money that disappears. The surviving family or executor of the estate will need to file a claim with the SSA. This will require documentation, including a death certificate and proof of executorship, but it is a process that is in place. This ensures that the injustice of the WEP and GPO doesn't extend beyond the grave. The money that was earned will be paid. Now, let's switch gears back to the more cautionary tale. The new SSI bank account verification rule. I want to spend more time here because this is where innocent mistakes can lead to devastating consequences, like a denial of benefits you desperately need. We established that this is for new SSI applicants aged 65 and over, and that it's based on having less than $2,000 in countable resources for an individual. The term countable resources is where the danger lies. Many people don't realize everything that the SSA can count against you. We mentioned cash and bank accounts, but it goes much deeper. Do you own any stocks or mutual funds? They count. U.S. savings bonds? They count. Do you own a second car? The value of that second vehicle counts. Do you own any property other than the home you live in, like a small plot of land you inherited years ago? Its value counts. The SSA is thorough. The purpose of this new automatic verification is to find these very assets. This brings us to the concept of spending down your assets to qualify for SSI. This is a legal and common strategy, but it has to be done correctly. You can't simply take $5,000 out of your bank account and give it to your son a month before you apply for SSI. The SSA has a look-back period for asset transfers. If you give away money or assets for less than they are worth, you could be hit with a penalty period, making you ineligible for SSI for months or even years. However, you are allowed to spend your money on yourself to become eligible. You can pay off existing debts, like a car loan or credit card bills. You can make repairs or modifications to your home, like installing a new roof or a walk-in shower. You can prepay for your burial or funeral expenses by setting up an irrevocable funeral trust, which is a very common and accepted practice. The key is that the money must be spent on legitimate goods and services for your own benefit, not just given away to hide it. The joint bank account issue is so important that it's worth repeating and expanding on. Let's create a realistic scenario. Let's talk about Margaret. She's 67, her husband passed away a few years ago, and she's living on a very small survivor benefit that isn't quite enough to cover her bills. She decides to apply for SSI to supplement her income. Years ago, she put her son, David, on her checking account as a joint owner, just in case something happened to her and he needed to pay her bills. It's a common, loving thing for a parent to do. Over the years, David has used that account to save for a down payment on a house, and he has $15,000 in it. When Margaret applies for SSI, the automatic system sees an account with her name on it with $15,000. The SSA's automatic presumption is that all $15,000 belongs to Margaret. Her application will be instantly denied because she is far over the $2,000 resource limit. The burden of proof is now on Margaret and David to prove that every single dollar in that account belongs to David. This could require years of bank statements showing the source of every deposit. It's a bureaucratic nightmare that could have been easily avoided by David having his own separate account. If you are even considering applying for SSI, you need to have a serious conversation with anyone you share a bank account with. It's clear that these two major changes pull the curtain back on the complex and often confusing nature of the Social Security system. It highlights the vast difference between the various types of benefits, a point that trips up so many people. Your Social Security retirement benefit is your money. You worked for it, you paid for it, and it's an earned insurance program. The same goes for Social Security Disability Insurance, or SSDI. You earn that protection by working and paying FICA taxes. Your assets don't impact your eligibility for these earned benefits. SSI is the complete opposite. It is a welfare program in the truest sense of the word. It is there for those who have next to nothing, and the government is now using technology to verify that with a fine-toothed comb. Navigating this new landscape requires you to be your own best advocate. It means celebrating the victory of the Social Security Fairness Act, but also being pragmatic about the rollout. It means if you are in the public service community, you need to get your paperwork in order and prepare for a potentially significant financial windfall. And it means if you or someone you love is struggling and needs the safety net of SSI, you must approach it with extreme caution and full awareness of these new verification rules. Go through your finances with a critical eye, understand what counts and what doesn't, and make sure your financial house is in perfect order before you ever fill out that application. This is the kind of in-depth information that can genuinely change someone's life. It can be the difference between a comfortable, secure retirement and one filled with financial anxiety and struggle. This is why I'm so passionate about making these videos. So please, take this knowledge and use it. Share it with your friends, your family, your neighbors. You have the power to help someone avoid a critical mistake or claim a benefit they didn't even know they were entitled to. Thank you for your time and for your commitment to being informed. Stay tuned, stay safe, and we'll navigate the future together.